an initial inventory and accountings that show over $1 million, and now it's at zero.
When this judge saw a disabled man's $1.2 million trust reported as zero, he immediately pressed the lawyers for answers on the missing disclosures.
The beneficiary would be the ward, and in that event, the money would go back to the ward as an adult, incapacitated, and then part of the guardianship, it would fund the estate. But right now, what happened in 2000, when this personal injury suit was settled, those settlement proceeds were used to fund and therefore create the supplemental needs trust. So it technically does not belong to him. It belongs to the special needs trust for the benefit. This is a tax protection and a benefit protection trust.
But would the ward lose any protection by disclosing?
Well, no. And if the court orders, I'm sure we could get the court to balance what is in that special needs trust. The way the IRS works on these settlement proceeds is in order to protect him from his Social Security benefits, it puts in the special needs trust. It's used to provide benefits that Social Security won't cover. But if we were to undo that trust, then Mr. Soto would lose those Social Security benefits. So typically, those special needs trusts go down considerably because by law, they can only supplement what Social Security doesn't cover.
Unless it does, and that would require disclosure, you see. In a perfect world, that you're absolutely right. In an imperfect world where lawyers sometimes take advantage of wards, disclosure would be necessary. From the court's perspective, the question the court has and must always answer is how to protect the wards under the court's supervision.
Well, either he doesn't need a guardian of the estate and just a guardian of the person, which would be what happens typically when somebody's just receiving Social Security benefits, or the court orders that the trustee to provide the court the annual to show what is on account. It's considerable, Judge. I think it's over in excess of 1.2 million.
And the problem you're going to have there, and I promise you this is going to happen, the very next time the Office of Court Administration comes and does a complete audit, we're not going to pass scrutiny because at time one, there's $1 million, whatever. At time two, and now it's at zero. So now the inference is you've gone out and spent $1 million. That's exactly what that report is going to show.
We can disclose the bank statements. It's just that in the reports, usually the guardian will receive the money and then make the payments. In this case, the guardian does not receive the money, but everything is paid through the trust. I cannot report that she received any money because she doesn't receive any money.
Well, then find a category and plug it in or create a new category where she absolves herself of liability, but discloses. I mean, in any event, she is guardian of his estate. So she still bears a duty and responsibility to at least stay on top of it, although she receives none of it. But at least that way, she can definitively show that under her care trust as guardian of the estate, everything has been managed well, even though she's not in charge of it. But see, now that we have an initial inventory and accountings that show over $1 million, and now you're showing zero, it ain't going to pass Austin. I'm going to ask for a full redo. Give us a setting in 45 to 60 days, please.